Okay, looks like we have a lot of questions, so I'm going to jump right into the questions. Maybe if somebody on my team could put on the screen how many total questions there are, that would be great, just so I know how to maximize our time here. Okay, the first question, if a homeowner in an HOA community signed an easement 20 years ago, allowing the HOA to maintain landscaping on the property they pay taxes on, and the house has since been sold, and twice since that easement was originally signed, do subsequent owners have to abide by the easement agreement? Well, if it's recorded, probably yes. If it's a recorded easement, I would say yes. Okay, looks like we have 47 questions. That's a lot of questions today. Okay, number 2, why are board members' names listed with the Corporation Commission? What does this mean, and what responsibilities come with being listed? I think the Corporation Commission, it's the law that the individual board members' names need to be listed. It doesn't mean anything other than, it's public record that you are a director for a nonprofit corporation in Arizona. And I mean, that's that. I mean, obviously, you're putting yourself out there by running for the board, and you are listed as a director, but it doesn't have any negative implications. I've never had anybody say that being listed with the Corporation Commission has been an issue. Okay, question 3. Some HOA CC&Rs, like ours, have impossible requirements for voting in amendments and edits to the CC&Rs. We need 75% approval to make any major financial move and amend the CC&Rs themselves. This is almost impossible. What can an HOA do when their governing documents themselves prevent amendments? So I agree 75% is pretty high. What you might want to do is amend the amendment provision. You'll still have to get 75%, but you can get it to a more manageable number, and it's kind of a non-controversial amendment, right? We're just amending the amendment provision. We're taking it from 75% to 67%, which is kind of the lowest you can go for a condo. Or maybe if you're a planned community, you go to 51%. So that's one way to get moving on maybe possibly having a larger amendment in the future, if you can lower that amendment require alone with the vote alone. Okay, question number 4. When a homeowner assessment account is 30 days past due, is there an automatic lien placed against the home? So I would say, generally speaking, no, but there is a lien. It's an unrecorded automatic lien. As soon as you become a record owner in a property, whatever the deed is recorded is potentially like a lien. But it's always best to take the extra step to actually do a written recorded lien showing how much is owed and stating that the number can go up and down, but this lien shows that there's something that's still owed. Okay, question 5. How does an HOA board make a resolution, and how is that different from a rule? So a resolution is, it's kind of outdated. People don't really use these anymore, but basically it would just be like, here's our resolution on how we're going to handle, our reserve account. And maybe the resolution is that all board members need to sign any sort of withdrawal from the reserve account. Like I said, it's outdated. Really, people are not using resolutions anymore. You just vote on things at the board meeting, and that's how things are handled. It's different from a rule in that there's rulemaking authority typically given to you in your documents. And, if you pass a rule, it becomes a rule and regulation for your association, and then the association can enforce it. A resolution was maybe more like something that we decided at a board meeting to do. Okay, next question, number 6. What is the community's recourse actions they can take against board members if a board member has installed a security camera in a pool area and is viewing footage on personal devices, and no notice or signage was ever posted or shared with the community? Okay, I think as a board, you need to talk with the board member. Does this person have the approval to do this? Is it on their property? Why are they facing it towards the pool? I think you probably need to get your legal counsel involved to talk through all of those issues with the owner, but the owner that's doing this, owner, board member, and hear that person's side of the story and find out more facts before I can, weigh in on that. But your legal counsel should be involved in the discussion on that. Number 7, where can we find HOA boundaries, mainly perimeter walls? Is there a county website we can find the info? So I would go to the Maricopa County Assessor's Office and use their GIS maps, and that should help you with the boundaries. They're not perfect, so you would want to get a land survey to make sure that for sure that something is or is not on somebody's property. Question number 8. Should the board alert owners about crime in our condo complex? I encourage you to go to our website, look at our cheat sheet called Preventing Theft and Crime in Community Associations and Limiting Liability. I think that's, generally speaking, what the name of it is. It's like Theft and Crime in Community Associations, how to prevent it. Should you alert the board about it, or owners about crime? I would say yes. I think that if there's been a string of people that have had their cars broken into, good reminders would be leave your garage door down. Don't leave valuables in plain sight. I think all of these are beneficial information that you can provide to the owners. Number 9, how does an updated CC&R relate to current owners? Do they just apply to future owners only? So anytime there's an amended and restated CC&Rs, it typically is going to apply to all owners, unless there's a special carve out with a grandfather clause for existing owners. Okay, question number 10. If an owner is not able to vote due to illness or another issue, who can legally vote for them? What legally are they required to do? So they should fill out an absentee ballot if they can't attend in person. That's my recommendation. If they're unable to fill out an absentee ballot, then unfortunately they probably aren't, able to vote in the election or whatever the issue is. Number 11. Is it acceptable for a homeowner to fly the American flag upside down? So we already talked about this in our presentation today. In my opinion, no, it's not. It's a violation of the federal flag code. However, this is kind of a dicey situation, and you can go back and re-listen to what I said earlier on this. You don't want to be on the national news, but I think I would request the owner to take it down and put it back, fly it back up pursuant to the federal flag code first. And really seriously consider if you want to pursue this question, because it is going to be something that's controversial and may end up having the association all over the news. Okay, question number 12. If a board-appointed committee meets and a majority of the board attends, does this constitute a quorum and fall under the open meeting law? So short answer on that is yes, even though it's a committee meeting. If a majority of the board is there and that's a quorum, absolutely, it's an open meeting. When does House Bill 2662 become effective? That's going to be 9/14/2024. Question 14. We have 2 board members who asked to be on the board. Over the past year, they have not participated in any decisions or board members or board business. How do we approach this with them? Should we ask if they want to resign? So I think whoever the president is needs to reach out to them and find out what's going on. And if they don't want to be involved anymore, then have them resign. Okay, no, it sounds like somebody said that maybe they're having a little trouble hearing me. Just keep letting me know. I'll continue to keep talking loudly. Sometimes there's technical difficulties, so sorry about that. Okay, next question. And just, if you miss my answer and that's your question, you can always email me tomorrow and I'll be sure to answer it by email. Okay, I'm just going to repeat that question again, just in case that was when my audio was breaking up. We have 2 board members who want to be on the board. They got appointed to the board, but then they haven't participated at all. How do we handle it? Basically have the association's president reach out to them and ask them to, what their intentions are, and remind them that they need to participate in the board and see if they want to resign. Okay, next question, 15. We have a new management company, but they insist they are bound by law to mail statements to homeowners. With the rising costs for first-class postage getting expensive, do we really have to mail statements to owners? We have some homeowners that pay their annual assessments in one lump at the beginning of the year. So the short answer is yes, the law does require associations to mail those. You can make a business decision that you're not going to comply with the law, but recognize there could be liability if you send it another way, and don't send it by U.S. mail. One way you could, limit that liability would be to amend your documents to state that, the statements can be sent to the owners anyway, or maybe they can look at their account if they want to find out how much is owed, and you don't have to send it by U.S. mail. Okay, next question, number 16. How do we guide our president to understand that their role is only 20% rather than a dictatorship? President and community manager are like them versus the rest of the board. We have a great group. We all want to work together. So I think probably a really good suggestion on this is there's a level of dysfunction on this board. Maybe consider having our firm come out and do a boot camp so we can talk through the issues, get the president to understand that, like, hey, yes, you are the leader. Part of being the leader is including everybody, and get air grievances and move forward through a very productive boot camp where we talk through the issues. And I kind of give a little nudge to the president and let them know that they can't do what they're doing, and that we all need to work together as a team. So I would recommend reach out to our firm if you'd like us to help you with that. Okay, question number 17. We are in the process of updating our CC&Rs. Do you suggest we address accessory dwelling units in this document? We do not like the idea of allowing ADUs in our community. I do think that's something that you should very strongly consider adding. Okay, 18. If we are incorporated as a nonprofit management group and do not have any amenities in our community, do we fall under the laws for planned communities? We are a nonprofit with bylaws and CC&Rs with no enforcement abilities. The purpose of our management group is to maintain the dirt roads and the operation of a large shared public water well. I guess I would have to see your CC&Rs to give you a specific answer on that, to see if you fall under the specific definition of a planned community under the Planned Communities Act. It does sound like you possibly are, though, so just at first glance, but I'd have to see your CC&Rs to know for sure. Question 19, want to confirm that signs and flagpoles applies to owner property. Condominium HOAs where yard space is common elements, signs can be prohibited. So yes, in a condominium, the only place that they're going to be able to, put the signs up would be in their window. Number 20, if the condo rules and regulations do not specify in words that the state law permission of date and times display, can owners display for outside those time restrictions? Okay, so if the condominium doesn't, so this sounds like a political science question. If our condo rules don't specify what the state law says for the times we can display the political signs, can an owner do it for outside that time period? So the short answer is no. You have to, the fallback is always the state law. Question 21, is there a requirement for an association to post an agenda prior to the open meeting? Well, yes, effective September 14th, that will be the new law. 22, is a candidate flag allowed? I think I addressed this kind of briefly in my presentation. So I think technically, if you're going to go like technical, probably not, although I think it could be considered a political sign. And I would say that I would allow that as long as it didn't contain offensive language. 23, are there specific state or local statutes that restrict other types of flags, like the pride flag or flags from foreign countries? So basically, the statute that I talked about in Arizona that applies to condominiums and planned communities, there are very specific flags that are mentioned that an association cannot prohibit. It does not talk about flags from foreign countries. It doesn't, talk about that. It doesn't talk about pride flags. So that would have to be something that you would have in your documents as to whether or not those type of flags would be allowed. Now, one thing that I would say is this is another hot potato. I would be very careful about prohibiting either of those types of flags. Okay, 24, our CC&Rs permit guest street parking for up to 2 weeks, only with advance approval from the board. They are silent on how frequently a resident may use on-street parking. Assuming a resident obtains approval for 1 2-week period, is it reasonable to deny second and subsequent requests for the same vehicle? We think the homeowner is trying to use this approach for a workaround for the 2-week limit. I mean, I'd have to see your association's documents to see what it says about residents parking on the streets, because it doesn't appear that this person is a visitor. So it doesn't appear that section in your documents would apply. So I'd have to look at the section in your documents that talks about where residents can and can't park. Number 25, my HOA has very strict rules. However, I see several of the don't tread on me flags being flown. Is this considered a flag that is okay to fly? So yes, I believe that's the Gadsden flag. And so that flag is allowable under state law. Question 26, our condo association has been approached by adjoining golf course for approval to install utility lines and equipment onto our property for use by the course only. Our documents are unclear if the board can approve an easement when it's of no benefit to owners. What are the risks of granting the easement to the golf course and other parties yet to be identified? Well, I'd be really careful about that. I would get your legal counsel involved or our firm involved to help you. First, I would check the documents to see if you even have the right to, grant an easement, and if so, for what purpose. And then I would look at what they're asking for and how that could potentially negatively impact the association in the future. I'd also check the plat map to see if there might already be some easements on there that you aren't aware of in that same area. Okay, question 27. Are HOA management companies registered or certified in Arizona? Or can someone just start a management company? So there is no registration or certification of management companies in Arizona right now. And so, yes, a management company, basically they would just incorporate probably or form an LLC and then start their management company. Number 28. If, and I say if, your HOA allows homeowners to speak in an open forum, can they mute you? If they say you are given a time limit and you are within that time, are they allowed to mute you because they don't like the question you are asking? So I am in favor of time limits. However, before someone is muted, I think we should give them like at least a 10 or 15 minute warning or 10 or 15 second warning or 30-second warning that, okay, like you need to wind it up because the time is almost up. I think that's the polite way to handle it versus just muting them. I think a warning first. Okay, question 29. Can the HOA prohibit these political signs, internal or general, from being placed on the common areas? So yes. So on the political signs, they only can be on the owner's property. And it can't be on common areas. Okay, question 30. What statute, rule, or code, or Robert's Rules of Order are there for an executive session during an HOA board meeting, and what kinds of things can be discussed during executive session versus an open meeting with the homeowners? Okay, so we already talked about this pretty extensively here in this class today. Go to our cheat sheet on board meetings, and we have it all laid out for you there in writing, so you can take a look at it. Question 31. In our HOA, all homeowner front yards are owned by homeowners, but the maintenance and management of front yards are assigned to the HOA. Plus, there are separate community areas. How do laws apply in this association? Can the HOA enforce restrictions in these areas as if they are the community area? So really how this is going to be handled is all going to be laid out in your CC&Rs. So who maintains the area, who handles what, like if it's a maintenance issue, the association handles it. If the tree dies, maybe the owner has to replace it unless it's the fault of the association, board not maintaining it or whatever. So it's really going to be dictated by what your documents state. Okay, question 32. Can HOAs put lawyer fees on homeowner ledgers where there is no judgment in court and no court involved? Generally speaking, yes. I would look at your association's documents for the justification to do that. Question number 33. You mentioned that the amount being paid to a vendor does not have to be shared in a records request from a homeowner. What's the reason for this? I think it's basically just the law. That's the way the law was written. I don't really know the justification for it. It's been like this for 25 plus years. Number 34. Is the board required to share with the community the exact breakdown of voting results for an amendment vote that did not meet quorum? I would suggest that the board should. I mean, you also could just ask for a copy of the ballots under a records request to find that information. What statute, number 35, what statute or law gives the owner the right to see contracts and owner rosters with property addresses? So if you go to our cheat sheet, the top 10 cheat sheet, we have the exact statute listed. It's number 10 on there. And I don't have it right at my fingertips, but go to our cheat sheet on our website at mulcahylawfirm.com. Click on the top 10 cheat sheet, which is top 10 things you need to know about Arizona law. And number 10 on that has the statute number and it lists the specific statute. Question 36. In this legislative session, House Bill 2325 passed and will go into effect in 90 days. This bill allows chickens on residential lots of 1/2 acre or less. Can a planned community override state law? Honestly, my office needs to look that up and look into that a little bit more. It's not like a direct HOA one, but we will report back on that in the future. So thanks for bringing that to our attention. Question 37, can a board member go on a homeowner's property and or backyard without permission? Generally speaking, if it's in the association documents that they have a right of entry to look at a violation after giving notice, yes, they can. If they don't have that provision, no, they can't. Question 38, can the board of directors raise the monthly dues or maintenance fee twice in the same year? I mean, it just depends. Are they following the documents? If so, yes, they can. It's unusual to have that happen, but sounds like there's unusual circumstances maybe right now at your association. Question number 39, question on removal of board. Once the petition is verified, is it the petitioners who notice, set up, and mail absentee ballots or the sitting board? It's the sitting board. The board, handles the all aspects of the removal meeting. Question 40, we have a micromanager board president that has canceled all committees. What's your view on committees? Well, I like committees because it helps the board get their jobs done, but sometimes associations are so small that they don't need committees. So I just have to probably hear from both sides on that before I weigh in on it. But I do think committees can be a very valuable tool and helpful to associations. Question number 41, what is the quorum requirement for removal meetings? So board removal meetings are going to be at 20% quorum. 42, do committee meetings need to follow open meeting laws and not conduct business via email? So if it's a regularly scheduled committee, meaning that they have regularly scheduled board meetings, our architectural committee meets the first Thursday of the month at 7 p.m. at the community park. If it's a regularly scheduled committee that has regularly scheduled committee meetings, they do need to follow the open meeting law. Otherwise, no, they don't. Question number 43, how can homeowners enforce the limited topics in the executive session? Meaning they say they will discuss only the legal topics that are okay, but then they discuss other issues. I mean, there's no way to enforce that. We just try to educate the boards to stick to only the executive session topics. And in my experience, I can't believe I've been doing it this long, but 27 years experience, 99.999% of the boards stick to that because it's usually the last thing on the agenda and they usually want to go home. So it's not like they linger. They talk about what's on executive session and they move on. Question number 44, how many days in advance should a meeting agenda be made available to the community? So 48 hours in advance, same as the notice. Question 45, if the property management company requires you view records electronically in their office, can you require the management company to supply the requested records in the same electronic manner? This is kind of a question that's harder because, I guess from our firm's perspective, if I have records that have been requested by an owner, it's so much easier for me just to pop them to them by email. But I'm not required to do that for free. We could print it out and leave it at our front desk and have them pick it up. So can you require that the management company give you records electronically? No. But I think on the flip side of that, management companies should just make things easy. We're not trying to hide anything. Let's give people the records that they want. There's no extra cost for us to email them to you. So why not give it to you for free? Question number 46, when renting from the owner, is there a way for renters to access knowledge of when the HOA meetings take place? Or are renters allowed to view meeting agendas? We are required to comply with statutes and decisions as they are made, but are given limited notice, and we hope to understand if there's anything more proactive we can do. So no, you're not, there's no requirement to allow you to attend meetings or to give you notice. I think what you need to do is talk with your landlord who's the owner and just say, hey, this is important. We need to know information as it comes out. Can you please share with us any information on the association so that we're sure to not violate the association's documents or any rules? Okay, question 47, whose decision is the allocation of the spending of reserve funds delegated to? So it's a majority of the board decides how the reserves are spent. Question number 48, if the HOA holds a special meeting and members are allowed to vote via absentee ballot, can an owner revoke an absentee ballot if they attend the meeting? Good question. So if it says on the ballot it's irrevocable, no, they can't. Most ballots do say that, by the way. If it doesn't say that, then it's arguable. You probably can revoke it. Question number 49. I'd written in my notes, language in the documents that violate Fair Housing Act can be removed from governing documents without a vote of reference, without a vote of the membership. What is the reference? It's one of the new laws that was just passed. I don't have it right at my fingertips here, but what I can tell you is once our cheat sheet comes out on this, you can look it up, or you can look it up online right now. It's Senate Bill 1432. Just go to the Arizona Legislature's website and type in Senate Bill 1432 and look at the law that was signed into law by the governor, and you'll have the language right there. Okay, question number 50. So where do we stand when the management company for our HOA subdivision says we cannot clear invasive weeds like stink net in the common areas that create a fire hazard? The literal interpretation of the statute is too restrictive and unreasonable. Okay, so it's apparently your management company says you can't clear invasive weeds. And how do we handle it? I am not that familiar with that law, but I mean, obviously we all have to comply with whatever the state's laws are on, clearing these areas so that we don't have a fire hazard. So, I mean, it's the law, so you're going to have to comply with it. Okay, question 51. When we leave a property management company for another, how can we require the old company to preserve our electronic records and transfer them to us? They use a third-party database product, so our records are within that database environment. If we don't hire a new company that also uses that system, we won't be able to view our full records. I mean, you should look at the management contract with the management company, because usually how the termination of the relationship and the records is transferred is laid out in the management agreement. Sometimes when the systems don't jive between the former management company and the new management company, the former management company prints out all the records, and then you have a copy of those records. Thank you, everybody, for being here today with us. Appreciate you caring about your associations, wanting to learn more about the new laws, wanting to learn more about, political situations and associations and our most commonly asked questions. Just a couple housekeeping matters. There will be no live First Friday event on July 5th, Friday, July 5th. Why? Because it's July 4th, the day before, my favorite holiday of the year. And we usually get very low participation on the holiday week like that. So we're not going to be having a live virtual First Friday event on July 5th, but we'll be resuming that again as usual in August, the first Friday in August. Our next virtual event then will be class number 7 of our 2024 virtual HOA Condo Academy, and that's going to be on Tuesday, July 16th at 11 a.m. We're going to be talking about amending CC&Rs, how to implement rental restrictions, and how to create a budget for your association. So those are going to be really good, relevant topics for you as you navigate summer months. Lastly, we ask if you wouldn't mind, please consider leaving our firm a review on Google or Yelp. We are sharing a link in the chat on how to leave a review. We're always happy to get feedback from all of you about how we can improve the classes, or if you like the class today, or if there's something that you'd like us to teach on in the future. That's a really great way to provide us with that information. So appreciate you doing that if you're so inclined to do. We have a link that we'll be sharing with you on how you can give us a review. Just some concluding remarks. Stay cool over the summer. I hope you all have a wonderful 4th of July holiday. Thank you so much for being here today. I think today might have been one of our largest attendee days. So thank you so much for being here today and caring about your associations and wanting to learn more. So take care, everybody. Have a safe summer, safe 4th of July. And we will look forward to seeing you in August for our next virtual HOA seminar. Take care, everybody. Have a great holiday.